primarily going to limit my part of the discussion, this first part, to the work that you do with the crime laboratory. Obviously, the CSI effect has influenced the way we present cases. I even now order my witnesses differently than I used to when I presented cases in the late 80s. It motivates us to find more evidence, or not find more evidence, but use more evidence in court, and that in turn puts all kinds of pressure on our crime labs. Part of the CSI effect is that oftentimes they go into the realm, they depart from reality, and you have jurors that may think that you can pour chalk into a knife wound to measure how deep the knife went into the body, those types of things. Machines that identify cologne on clothing. And they depart from reality because our crime labs really can't do that kind of work. The other thing that's not shown on CSI because of the limited time that they have is the kind of work that a lab has to do, validating the forensic testing methods that they use and the tests that they run. Obviously, the documentation for chain of custody, always writing down exactly what step was taken. You know, that's not going to get you good ratings on a TV show, but it's absolutely important for good forensic testing. And in order to present that in court, you want to make sure your jury understands those types of steps were taken and that type of validation work took place. The negative effect of CSI, it has an effect on our victims. We have victims at crime scenes that think that the police show up and they can, just with blue lights, can do all kinds of things that they can't actually do. And obviously that when there are things that can be tested, waiting for backlogs that we have in all of our states across the country, that causes frustration with victims. Everyone is getting educated by all the types of shows that we've talked about, the true crime stories, those types of things, and hopefully you're engaging in that kind of education of your law enforcement agencies to help them better understand what they can and can't do as far as the CSI effect is concerned. So as investigators realize that this is the kind of thing that can help them, they are making requests from the police side that is putting pressure on the labs. And oftentimes you're finding that the investigators that are working on murders and rapes are frustrated by the backlogs that are happening at the state labs. The problem that I see with the CSI effect that is sometimes trumps the common sense that we all use when we're talking about utilizing resources that the lab has. And our lab, it has very limited resources. And when I have prosecutors that are requesting testing that is not necessary or not relevant, I start to see how the excuse for that is, well, I just want to show that we had that done. There's a recent NDAA paper that was very concerning to me in that it was written by prosecutors and quoting prosecutors that said that you ask for testing even when you don't need it. The problem with that is that there are plenty of cases that you do need testing on. And so to waste the time of your forensic analysts in doing that testing, you're further putting back those cases that could be solved, could be resolved as a result of forensic testing that is necessary in those cases. Making police, criminal experts, prosecutors, and others do more forensic testing, even if it's unnecessary, I don't agree with that paper. I think that that's a very bad thing to do, to waste those resources. And a prosecutor that is saying that they have been asking to have evidence submitted for fingerprints and DNA on a regular basis, even when they have a confession or they have an admission of guilt, to show the jury that they're doing their job. I believe that's a prosecutor that's not doing their job. I mean, if you have one or two items of evidence that you need tested, that's what you should submit. You shouldn't submit all your items. You should go through a process of figuring out what it is that would help your case and present that request to the lab so they can get to work on that. A lab should set a submission policy. They want to streamline their process and turnaround time. It should be a written request. with some circumstances around the case so the analyst understands the nature of the request. And I think a good lab should set a limit on the number of items that it's willing to test on a case. Obviously, that limit should be something that can be changed if you sit down and talk to them and explain to them why you would need additional testing. I think it's important for us as prosecutors to point out certain things about our cases. What are the discovery cutoff dates? So when does the lab have to have their results done and the background discovery available for defense counsel so we can turn it over based on those kinds of dates? We often see labs sitting there doing testing on cases that we've resolved. So if you've plea bargained your case, or you get a plea on your case or dismissed your case, you should notify the lab so they can stop all their testing and start working on cases that are still in the system that still need DNA testing. Obviously, Norm and Ted will talk about preparing your witnesses, but you have to sit down with your experts and talk to them about dealing with the CSI effect during their testimony. Inform them of any verdicts that you get, and if you get any feedback on the analyst and the work that they did, how they testified from the jury and the judge, notify them of that. We evaluate all our forensic analysts after they have completed their testimony, and that's feedback to their bosses, and obviously it's very important for them to know what the verdict was in the cases that they've worked on. I think that there's an interesting thing when we do have forensic science or forensic evidence in our cases. Sometimes it's very complicated depending on how you present it. That's not the way it is on CSI. And I think you have to sit down with your forensic analyst and prepare them to make sure that they're not using terms that the jury can't understand and that they can simplify what it is that you're trying to present to them, and that would probably make it closer to what the jury's used to seeing on CSI. One of the concerns we always have is the ethics of the forensic scientist. You want the forensic scientist to come across as an unbiased, honest, incorruptible seeker of the truth. CSI makes these people out to be investigators. They basically do everything. They're at the crime scene, they do the testing, they actually arrest and sometimes interview the bad guy. But you don't want to have that kind of situation. You want to make sure that you present your forensic scientist in a way that they come across as unbiased, just as a scientist, and it's their job to present the evidence that they found and not to nab the bad guy. We've seen situations where prosecutors have tried to have the reports changed, that type of thing. That's going to lead to problems. Then I wanted to talk just a little bit about negative evidence witnesses. Obviously, using negative evidence witnesses and preparing your witnesses to explain that it's not unusual that they don't find fingerprints at a certain type of crime scene or on a certain type of item. You have to have your witnesses prepared for that. And I think that you have to have more than your experts prepared for that. You have to have your detectives prepared to answer those kinds of questions. One of the techniques that I've seen is the defense attorney will ask the non-expert witness about DNA or about fingerprints, and you have to have them prepared to answer those questions and deal with them in a way that it sets up, if you do have experts coming in, to answer those questions. But they need to know about that because they're usually going to testify in the chain of custody or at some time in your trial prior to you calling your expert. You need to have your expert ready to prepare to explain to the jury why there is no scientific evidence in a case and what that means. Actually, there's 4 possibilities: that there was no contact between the victim and the suspect. There was contact, but there was no transfer of hair or DNA, fingerprints, anything like that. There was a transfer, but the evidence wasn't collected, or it wasn't something that could be detected. So you have a transfer collected but not detected, so it was not a good fingerprint, that type of thing. And the interesting thing is when I've called these types of witnesses and had them testify to this, the probability of one of the 4 is no greater than any of the others when you're talking about negative evidence. You may see a situation where the defense tries to call a negative a defense expert to testify about flaws and lack of forensic evidence in your case. You really should fight this in limine pre-trial, and the judge should not allow this kind of expert to testify in your case. If the judge doesn't go with you, doesn't rule in your favor, and does allow the defense to call this type of witness, then in rebuttal you should be prepared to call someone from the lab to rebut this witness, or even consider calling a negative evidence witness in your case in chief if you're not going to get the opportunity to do rebuttal. The benefits of the CSI effect: it's educating our victims. Back in the day, Norm and I used to see victims that would take baths, they would destroy evidence. Now they've watched those shows, and that helps us that's one of the benefits of the CSI effect. In Denver, we were very lucky to be able to run a political campaign to get a bond issue through to build our lab, and it was basically, our theme was CSI Denver, give us this new facility and we'll be able to do more and more work and solve more and more crimes. So obviously there is a very positive outcome from your voters watching the CSI. I believe that's my last slide.
Excellent, thank you. Mitchell, that was excellent. Very interesting. We'll hold any questions pertaining to that section until the end. And just before we move on to Ted Hunt, I just wanted to say to folks, there has been a question up there whether this program will be available online later on through the PowerPoint slides, and yes, it will. So look for that later. Now we're going to turn to Ted Hunt, and he's going to talk about working with the police on forensic evidence collection and testing decisions.
Welcome to the CSI Effect. My name is Ted Hunt. I'm Chief Trial Attorney at the Prosecutor's Office in Kansas City. CSI Effect basically is a euphemism for the idea that some jurors have unrealistic expectations about the questions that evidence, particularly forensic science and modern technology, can realistically answer. But it's important to stress that the CSI Effect is not necessarily limited to jurors. It can include police officers and detectives as well. And that's the focus of this part of the presentation. The basic problem, as I see it, is that some investigators may think that forensic evidence, and particularly nowadays DNA, can conclusively answer all of the questions in a criminal case without first taking a close look at the pre-existing probative value, or the lack thereof, of items that they may ask the crime lab to test. They may also not understand how evidence will be attacked later and a different spin put on it, and the results that the lab gets from those that were anticipated by the police. Really, the goal of any crime scene investigation should be to identify, to document, collect, describe, and analyze probative evidence. And that sounds simple enough. Police are supposed to be experts in evidence collection and analysis. The problem is that no matter how skilled or experienced any police officer has become, they may lack the perspective of having seen the entire lifespan of an item of evidence from the point of identification at a crime scene to the presentation of that evidence in court. The latter part of this lifespan involves lawyers and defenses and arguments about what the evidence means. So the inferences drawn by the defense may be very different than those placed on that evidence or drawn by or anticipated by the police. And this is where the importance of establishing what I call evidentiary context comes into play. Establishing context and probative value really limits the range of reasonable inferences that can be drawn from the evidence, and this is the first step in trying to counteract the CSI effect. The first question that any cop who comes to a scene has to consider is, which of this stuff here is evidence? Articles, items, and substances found at a crime scene actually become evidence through the very human acts of identification and assignment of significance. And there is really an infinite variety of things at a crime scene. There's the collectible stuff, basically anything that can be identified and carried away. There's the stuff that actually gets collected. Of the stuff that gets collected, there may be a smaller quantity of items that are actually material in a legal sense, meaning that they have a possible connection between an issue in the case and the evidence itself. Of the items actually that are material, there are those that actually get analyzed, which is even less than what's material. And of those items that get analyzed, there may be an even smaller number that are actually significant in the context of the case. So from a collection and testing perspective, it's really essential that forensic question begging be avoided. And by this I mean attaching significance to a testing conclusion without first establishing the contextual probative value of the item itself. And in practical terms, this is a shoot first and ask questions later approach, and that's not recommended. Instead of facing the CSI effect head on, this practice really enables and promotes and facilitates unrealistic expectations of forensic evidence and technology. So always remember, before the result comes in, the evidence itself from which that DNA profile, for example, is detected, that item has to be significant before the test comes in. So the recommended approach for evidence collection and testing decisions is really based on a logical assessment of the evidentiary context of the candidate item, together with a determination of its relevance, and that should go hand in hand. It's important to remember that an item of potential evidence has to possess that probative value at the time of collection before testing. And a matching or an exclusionary result by itself and without consideration of the item's pre-existing circumstantial significance will not transform an irrelevant item into a relevant one. And context is really foundational to a meaningful and probative forensic test result. So what do I mean by context? One definition is that which surrounds and gives meaning to something else. And when I look at evidentiary context, I look at it in terms of three levels that ought to be recognized and considered when assessing its probative value. The first level concerns the intrinsic aspects of the item, the object, or the sample, as well as the circumstantial significance of that item based upon an assessment of factors at the scene. Second level takes a look at the information provided about the item, object, or sample by, for example, a victim, a witness, and a suspect. And the third level concerns the testing conclusions and statistical weight, if any, that accompany a match. At level 1, the analysis interpretation is most often performed by crime scene investigators who discover, document, and collect items at a scene that they've determined to be evidence. Information used to assess the second level of evidentiary significance is usually collected by detectives who interview victims, witnesses, and suspects. And these interviews, during which questions may be asked about the items collected at a scene, might create or enhance or even diminish or destroy an item's circumstantial significance. Level 3 significance comes from the forensic testing interpretations and conclusions by lab personnel. Test results may include, exclude, be inconclusive with reference samples collected from those individuals who are relevant to the case. So when I look at evidence, I think about these 10 non-exclusive factors that I'm going to share with you here when assessing the circumstantial significance of a potential item of evidence. And I think this is something to think about as attorneys, but it's also something for crime scene investigators and lab analysts to think about as well. First of all, is the environment in which the evidence was found open or closed. For example, was the item of potential evidence located at a scene that was enclosed or contained? Or rather, was it open and publicly accessible? Second, was the item native or foreign to the environment? Did it appear to belong at the scene and be consistent with other items of a similar nature, or did it appear not to belong in the environment in which it was found? Third is the nature of the item, article, or substance. For example, was it blood, semen, saliva, hair, or tissue? Fourth, what was the location of the item in relation to other relevant persons, places, items, articles, or substances? Fifth, what, if any, relation, meaning what connection, either direct or inferred, does the item have with other relevant persons, places, items, articles, or substances located at the scene? Sixth is action, which relates to whether or not there's an inference of movement, force, or velocity related to the particular item at the scene. The seventh is quantity, that relates to either the abundance or scarcity of the item at the scene. Eighth is rarity, which refers to either the commonality or the infrequency of the item, either in general or at the crime scene environment in which it's found. Ninth is portability, that refers to the ease or difficulty by which the item, articles, or substance is transferred from one place or location to another. And 10th, finally, is condition. Condition involves an inference about the length of time an item has been at a scene based on its external and or its internal characteristics. So looking at these non-exclusive factors, investigators and analysts should consider these along with others when considering what among the countless items at a scene can be collected and then what should be actually selected for testing. So these factors are also helpful for attorneys in deciding what additional items of evidence you might recommend that your lab analysts test in addition to what the police have already requested. Now, I have to emphasize that no matter how circumstantially significant an item of evidence is determined to be, if that fact is not properly documented and communicated to the crime lab or to case detectives and to attorneys, it may completely fall through the cracks or be lost to time and memory. What you have before you is an actual evidence submission request. It says, officers recovered swab of possible DNA from recovered stolen auto. Please examine DNA sample. And if you have a request like this and there's no further documentation that exists, the sample, although potentially very contextually probative, is going to be useless. Questions that quickly arise are, was it recovered from inside or outside the car? Was it recovered from the seat or the door handle? From the steering wheel or the gear shift? From the radio or the trunk? We just don't know. So the sample's value is lost because of poor communication, even if it was very contextually relevant at the scene at the time of collection. So this is an intermediary step that is very important to remember, and poor documentation like this can cause a very relevant item of evidence to be in effect lost. So police need to be reminded to be explicit in their descriptive documentation of physical evidence. First, the object or the body or the surface of collection needs to be made clear. Second, the location of the collection on that body, object, or surface needs to be made explicit. And third, the measurement parameters of that location where the sample is collected need to be included as well. The second level of significance relates to statements made by the victim or witnesses or the suspect that may assert or deny or omit information about the questioned item. Now, these assertions can cause otherwise irrelevant crime scene artifacts to become or to be transformed into evidence with this additional context provided by what people say about items. And it can also diminish or destroy the circumstantial significance of items that have been previously believed to be evidence based on a look at the level 1 analysis of the scene. A victim in a burglary case, for example, might notify investigators that she doesn't smoke and that the cigarette butt that's in the kitchen sink wasn't there before she locked her home and left for work. It doesn't belong in her home, so the item is foreign to the scene and is associated with the crime. Now, investigators may not have known that just looking at a cigarette butt, but it added context based on the statement. Alternatively, in a burglary case, a screwdriver on a bedroom floor belongs to the victim and is not foreign to the house, but it was last placed by the owner in the kitchen drawer, not on the floor. So it's not foreign to the scene, but it is associated with the crime. Finally, with some items, the owner won't be able to tell if something's out of place or has been disrupted, so their statement is effectively neutral to the circumstantial significance of the item. So in order to clarify the contextual significance of items discovered at a crime scene, investigators should, with the aid of victims and witnesses, document the relevant circumstances at the scene both before and after the criminal event, paying particular attention to items of interest, noting, for example, in a burglary case, that particular items are, according to the victim or the witness, native or foreign to the scene and were not present when the scene was last secured. Or alternatively, that the item is not foreign to the scene but was altered or manipulated in some way by the suspect. There are also items that are used during the crime and taken by the suspect that are later recovered by police. Now, these items must be shown to the victim or the witness and identified before they can have any connection to the case and actually become evidence. So think of this as an evidence show-up, similar to a suspect showing up in which the victim identifies the suspect shortly after the commission of the crime. Without the third step, the item is absolutely irrelevant because it hasn't tied up and shown to be relevant and probative. So switching to a DNA example, there are a number of different inferences that any defense attorney can draw from that evidence when faced with a DNA match to his or her client, and among them are, in a sexual assault case, for example, evidence of the semen was consensual or explainable. The evidence was somehow planted. In a different case, maybe it's some type of innocuous or innocent transfer of evidentiary material. In a different case, it may be contamination. In a different case, it may be, well, the testing is unreliable. So there are many different inferences that can be drawn from a DNA result. Maybe not all of them reasonable or compelling, but they're plausible to some jurors. And this is where the importance of tying down the evidentiary context comes into play and becomes very important. But one way to do this is to have investigators create or enhance evidentiary context while limiting the reasonable inferences that are available to a suspect and a defense attorney. One way to do that is to have the police obtain facilitated denials from the suspect during the interrogation. And we all know the first instinct of any criminal is to deny having committed the crime. In a DNA case involving rape, for example, the act of showing the suspect pictures of the scene and the victim and providing the location, the date, and the time when the crime was committed while documenting the suspect's responses and his denial of knowing the victim or having ever been at the scene of the crime will enhance the inference of a criminal transfer of the evidence by the suspect to the victim. And the science is going to beat the suspect's story in almost every case. At trial, the effect of getting this denial during the interrogation will be to pit the scientific results against the suspect's version of events. So once the suspect becomes aware of the DNA results after he's been charged, that fact may force him to change his trial defense to consent. However, the damage to his credibility because of this changed version of events will be devastating. So to sum up, in order to satisfy the descriptive requirement of establishing the contextual relevance of evidence, investigators should provide a specific description of the evidence in their reports. The evidence should be documented with sufficient photographs to capture its context and time and place. Next, statements from relevant persons, including victims and witnesses, should be taken to clarify the significance or insignificance of the item observed. And finally, without informing the suspect about the existence of the evidence, he should be interrogated and asked whether he has any connection to the person or place from which the evidence was collected. Unlike victims or witnesses, however, it's usually a mistake to inform the suspect about the existence and presence of the item of evidence itself, because then he can incorporate that evidence into his version of events, and then he can, later at trial, without damaging his credibility, repeat the story that he had earlier told the police. With level 3, this relates to the forensic testing conclusions and the statistical weight, if any, attached to a match. In DNA testing, for example, the statistical weight of a match can range from less than 100 to quintillions and greater. Other methods of forensic analysis may not be quantitative, but can nevertheless include or exclude a particular individual. Depending on the test used and the weight attached to a match, if the testing conclusion can be expressed quantitatively, the result as an aspect of contextual relevance can have a great impact on the significance of the evidence. Although a testing conclusion alone will not alter the pre-existing contextual significance of the item analyzed, the probative value of that item can be greatly enhanced or diminished. So in summary, it's important to work with investigators so they don't neglect to fully determine, document, and establish the significance of a candidate item of evidence located at a crime scene. As stated before, this is accomplished by an analysis of the circumstances surrounding the candidate item, the taking of statements from relevant persons, and finally the forensic testing of significant crime scene items. But don't test everything. Remember, if you decide to test an item, you've just implicitly conceded to a future jury that you believe the item is contextually relevant, whether it actually is so or not. So otherwise, why did you test it? It's equally important to meticulously document those contextual circumstances surrounding an item and communicate those details to the lab when the evidence is submitted. Finally, only items that have first been determined to have pre-existing significance based on an analysis under levels 1 and 2 should be collected and tested. As I said before, these guidelines are equally applicable to investigators, analysts, and attorneys.
All right, Ted, thank you so much for that information, critical information on forensic evidence, working with evidence. And we're going to move right now straight into the courtroom with Norm Gahn, who's going to talk to you about addressing juror expectations. Norm?
Thank you very much. Good afternoon. I can't say with absolute certainty whether the CIS effect exists, or exists to the extent that it has an impact upon the decision-making process once the jurors go back into the deliberation room. But I do know from my experiences that odds are the jurors that are coming with the jury panels for our cases have exposure to these shows. The shows are popular, there are many of the shows, and they're very sophisticated. So they're probably coming in with some expectations, and therefore I don't think that we can ignore that fact. Maybe they're not coming in with an actual expectation about the forensic sciences, but at least they're coming in with an anticipation that they might get some scientific evidence in the trial that they're about to hear. So recognizing that we can't ignore this CSI effect, I think it is critical for us to prepare early on for it, or at least think it through early on in our preparation for trial. The jury pool is familiar with the content of the fictional versions of criminal investigations and evidence collection, crime lab procedures, and the prosecution of cases. As prosecutors, we have the task of keeping the jurors' feet on the ground. We do not want them judging our evidence by TV standards. Whether we can completely alleviate this influence, the CSI effect influence, I don't know if it's possible. But I think we have to thoroughly plan for it, plan a strategy, and think about it well in advance of trial. There are a number of preemptive steps I think that we can take to divert jury's attention, or divert them from reliance on these TV style expectations that they may have gotten from shows like CSI. One of the things about the CSI effect is that it can drive us crazy. And I have enough things in my life that drive me crazy that I like to limit them. So this is one of the areas that I like to limit. Where do you address this CSI effect? And how do you do it? There are many, many stages during the trial that you can address it. And I am not in favor of addressing it in all of the stages of the trial. Sometimes I think it can be harmful to us. But what I like to do, and how I like to prepare my cases, think about my cases, and when addressing the potential CSI effect, I concentrate on some generic voir dire questions, and I like to answer the CSI effect with my case in chief through my direct and redirect examinations. I concentrate on a few generic questions to the jurors about the CSI effect, and then structure my case in chief to dispel any of those false, unrealistic, or misplaced knowledge that was gained from these fictional TV shows, and any misconceptions regarding the presence or the absence of evidence at trial. I like to structure my case in chief that if there are CSI viewers on my jury who remain there, and ardent CSI viewers, I like to use my case in chief to capture their enthusiasm, shall we say, and to capture their interest. But first, you have to analyze your case and take a real good look at it and think it through early on. If I have a case where I have a lot of forensic science disciplines in it, and we have a lot of probative evidence with a lot of associations that I need to prove my case beyond a reasonable doubt, I'm probably not going to mention the CSI effect at any stage whatsoever at the trial. I'm not going to drive myself crazy thinking that there may be some juror out there expecting some outlandish or fantastic aspect to criminal investigations or testing processes or capability of technologies. I'm not going to address it when I have a very powerful case with forensic science. There are also going to be cases where you have a lot of forensic disciplines with probative associations that you need to prove your case beyond a reasonable doubt, but there also are untested items of evidence. I've heard prosecutors want to go into that, and they worry that the jurors are going to wonder, why weren't these other items tested? I, again, probably would not address the CSI effect, at a trial like that. I'm just not going to get pulled into such a worry and concern. I sometimes think if we get too wrapped up with this CSI effect, it can take us off our game. I've charged this case. I know what I've charged. I believe the defendant committed the crime, and I believe that I have evidence beyond a reasonable doubt that I can give the jury, and I don't want to detract from my presentation of the case with some worry about some evidence I might not have, or worry that some juror might wish that they had this type of evidence. The cases where it's a bit more troublesome is where you have your credible victim and eyewitness testimony with admissions and circumstantial evidence. You basically have no science at all. Here probably I am going to do a little bit of CSI questioning, a little more specific at the voir dire process, and I will really tailor my case and may even talk about the absence of that scientific evidence with the jurors. But still, I want to keep on my game and be working towards my final argument when I will be talking to the jurors about they are to decide this case based upon the evidence that they heard in this courtroom, and not about evidence that they wish they had or they thought they should have, or something that might have been available they saw on TV. I'll save that for closing argument. Where I see the CSI effect more is in those cases where you have evidence that was not collected, or it was collected but not submitted, or collected and submitted but not tested. Here is generally, I see where the defense opens the door here. They are going to use this to weave their reasonable doubt. And these are the cases that I like to employ my trial strategy in addressing the CSI effect by asking some generic questions, basically about the TV viewing habits of the jurors, and then weave that case in chief in my direct and my redirect examinations. Not directly talk about the CSI effect, but indirectly answer questions that the jurors may have about evidence that was not tested or collected or not submitted. But again, we have to be careful and not drive ourselves crazy. We have to be careful about the message that we send the jurors. I myself have been doing trials for many years now, 27 years, and I just don't like sending any type of message to the jury that I have a weak case. I don't like sending in any way a thought that I'm uncomfortable with my evidence. That's why I'm probably, when it comes to the CSI effect, I'm very, very careful with it, because I'm very concerned about what the jurors are taking away from what taking away from the message I'm sending them if I bring up issues that may not be issues, or I bring up items that were not tested. I like to wait actually for the defense to bring up those issues. The issue of untested evidence or uncollected evidence or non-submitted evidence, that issue isn't crystallized yet at trial, and usually it takes the cross-examination by the defense attorney of one of my witnesses, police officers, or crime lab. And at that point, it becomes crystallized, and that's when I want to address it, and that's why it is important to think very early on about how I'm going to plan that out in my trial strategy. And I have found that oftentimes in these type cases, my redirect examination is almost more important than my direct examination. So, and the other thing too we have to remember is that as prosecutors, we have a very unique bond with these jurors that no one else in that courtroom has. The judge doesn't have it, the defense attorney doesn't have it, the bailiffs, the court reporters, only the prosecutor. And that special, unique bond that we have is that during trial, our burden becomes their burden during the deliberations. They are looking to us to give them the information and the evidence that they need to make their decisions. And that is why I like to concentrate on the evidence that I have and how powerful it is and how compelling it is and how it constitutes proof beyond a reasonable doubt, and not spend a whole lot of time on evidence that I do not have, or worrying about their expectations or misconceptions about the criminal justice process. And again, we can drive ourselves crazy when we try to think about these expectations or these misconceptions that jurors may have. Good Lord, I have no idea where these expectations may be coming from or where these misconceptions may be coming from. Is it with the science itself? Is it with the investigation? Do they have expectations or misconceptions about crime scene technology, crime lab technology, crime lab testing processes? Do they honestly believe that they can swab something and put it into the machine and a perpetrator's name and photo pop up on a computer? Who knows where these expectations come from, what they are, or what their misconceptions are, and I don't think there's any way we can ferret that out during the voir dire process. But I do believe that during our case in chief, we can answer a lot of the questions and answer their expectations and misconceptions that they may have based upon the CSI effect. Sometimes you may have a case that does require some specific voir dire questioning. I'm not denying that. I've had cases like that. There haven't been that many, but I have directly asked the jurors, will they be able to convict if they don't have any scientific evidence? Sometimes you have to zero right in on it and get very, very specific. And here's some examples on the slide of some questions that you may have for the jurors. This is going to change and depend on the jurisdiction that you're in, what the court allows or what your laws allow. But these are some questions that I have directly asked jurors, and I believe they're proper questions to make sure that they can follow the jury instructions and make their decisions based upon the evidence that they hear in the courtroom. But generally speaking, I like these generic voir dire questions where I don't get too specific, especially in the case where there might be missing evidence or untested evidence. And basically what I'm doing is I am asking the jurors to focus on the reality of the criminal investigation process, that they're able to distinguish fiction, that TV is entertainment, that they're not being educated by TV, but that they're being entertained. And I like to bring out as much as I can during the trial real life versus myth or fiction, and show that this criminal justice system just does not operate the way TV production portrays it. And So I don't get real specific. I ask these type of questions with my case, and these are setting up, I call them setup questions for the rest of the trial. I'm kind of setting up my case in chief by these questions and setting up my closing argument. And the goal that I have is that I want to introduce this real life versus fiction myth theme during the voir dire, and then develop it in my case in chief, and then tie it all up during my closing argument. I don't know really what the exposure to the jurors is to these CSI type shows and their spawn, but by weaving the real life cases during your direct and redirect examination, I think we can answer an awful lot of questions that the jurors may have when they come into the courtroom. But first, it is essential, excuse me, as a prosecutor, that if you have a case where there is missing evidence or there's something wasn't tested, and the defense is on cross-examination of your crime scene detective, and they're pounding away on this. Why wasn't this tested? Why didn't you take fingerprints? Why didn't you swab for DNA? Or why didn't you, or the crime lab analyst is on the stand, why didn't you test for this? As a prosecutor, we have to be completely knowledgeable of whatever that forensic discipline is about its capabilities. And we also have to be completely knowledgeable about the limitations. And I have found through my experience that it's on redirect examination. Once the defense has opened that door and they have introduced into the trial the missing evidence or the untested evidence, and they're trying to use that to draw their, to weave their reasonable doubt, I found that the redirect examination, as long as I am prepared for it, that I've anticipated it, and I've prepared my witnesses, can take care of that issue and answer all those questions for the jurors. You want to give the jurors a realistic understanding of what the science can deliver. And so during the preparation, well in advance of trial, you got to think this through. Think about what you're going to have to know about the particular discipline and be able to come back on redirect and clear it all up for the jurors. Throughout after talking to the jurors in voir dire about being able to distinguish between real life criminal investigations and the fiction they see on TV, well, develop that. I have found myself developing the crime scene testimony far more than I ever used to. The jurors see the CSI type person come to the scene, and there's the body in the kitchen, and there's a head wound and blood is oozing out of it, and right next to the body is the pan or the candlestick or something. It's usually very simple, linear, conclusive evidence, and it's all right there, compact in one view. That's not how it is. And explain to the jurors exactly what is going on through your investigators at that crime scene. Describe the pandemonium that is going on about arriving at the crime scene and the crowd control and the drunken people, and the victim's family is fighting with the defendant's family, and people are in and out of the apartment where maybe the body is found. People have touched it. Environmental conditions that can contaminate the evidence. All the problems that actually go on at a real-life crime scene. And it is not until we have control of that crime scene that those professional policies of crime scene processing and evidence collection take place, and that the jurors will know that prior to the police arriving there was all sorts of things going on at that crime scene that can have an impact on the collection and preservation of the evidence. Things could have been moved, taken from the scene, how rare it is to find a weapon at the scene of the crime. Really explain what is going on, and what you're doing is the jurors now are seeing something real life, and they're being able to make that distinction between the real life crime scene and what they see on TV. And every time we can draw that distinction with the jurors, I believe it is having an impact on them, that they're sort of tilting in our favor and are more willing to listen to what we have to say every time they realize that real life situations are not what they're seeing on television. Basically show, and for all we know, there's a juror on there who is an avid CSI watcher. They watch it all the time, and maybe that juror is not impacted at all by the science, by the technology, that what they want to see is dedicated, hardworking investigators at the crime scene. Maybe they just want to see professional people doing their job. And this way, let's give that to them. And that may very well answer any questions that they may have. And again, every time that you can determine, distinguish real life from TV fiction, bring it out in the case. I don't stipulate the chain of custody. I just think that it's important for the jurors to see how careful, how professional, how dedicated our police officers are at the scene. I want the jurors to see that not one person comes to the scene and analyzes the crime scene, comforts the victim, questions the defendants on the scene, questions witnesses, collects the evidence, takes it to the crime lab, tests it, and goes to court. That's not how it works. We have many people involved. We have crime scene technicians. We have people who take the evidence in. We have people who document it for the chain of custody. We have transport people, crime lab intake people. Give them real life. TV edits out all the tedious and less dramatic aspects of a criminal investigation. I think it's important for the jurors to see those tedious and less dramatic aspects because it shows real life, true investigations. And every time we can distinguish for the jurors a real life investigation from something that's fictional, I believe that the jurors are tilting in our favor and they're more accepting of what we have to say because they're seeing what really goes on at a crime scene. When you get to the crime lab, I don't stipulate their credentials. I want the crime lab to see the depth and the level of the education, the training, the expertise, the experience of my people. I think it's important for the jurors to see that. Competent, professional people doing the work. The jurors, after watching these shows on TV, just come away with unrealistic expectations about the time and the effort that it takes to process a crime scene, or the time and the effort that it takes to do a crime lab test or analysis. There's just so much more science and technology that is involved, that is depicted on TV. And if you have a case where you have uncollected evidence or untested evidence, or for some reason the crime lab it did not test an item, and you're concerned about it, give the jury a reason why an item of evidence was not collected or tested. You have to satisfy them with a reason. I do believe that if there was some test that could have been done out there and was not done, the jurors will hold that against us. I do believe that that can start the weaving of the reasonable doubt for the defense. And if there is an item of evidence that was not tested or was not collected or submitted, you have to explain that to the jury. And don't do it with a very, very positive questions that develop that reasoning for the crime lab. You don't want the jurors thinking that something was not tested or was not collected because of incompetence or laziness or lack of care. Don't just ask your crime lab, why didn't you test this shirt? Start out by asking, would you describe to the jurors what exactly you did with the shirt when you began your examination? And then let your crime lab analyst then run with it and talk about the chain of custody and opening up the bag with the shirt and placing it on the sterile bench and what they go through, that visual examination for any type of trace chemical stains, cuts, holes, rips. Have them explain the preliminary presumptive confirmatory tests that may or may not have been done and the decision whether to forward it on to the laboratory. What you're doing is then leading up to the question of, well, did you send this shirt to other sections of the laboratory? No, I did not. And why not? And let the analysts state that based upon their examination, there was no apparent probative information that could be developed from this item. That is the decision that I made. Jurors will accept this. I believe that jurors will accept reasons why Evidence was not tested. You can even go into resources at the crime lab. How many items are submitted on an annual basis? This is giving the jurors a reason for why some item was not tested. So that really kind of wraps up what I have to say, and I thank you for your attention.
Thank you, Norm. That was excellent, and we're going to move into one final section, which is really going to expand on what Norm was talking about. From Ted, he's going to talk about some issue anticipation and expert testimony, things you can think about. Ted?
First of all, I'd like to agree with what Norm said. I think in many of these cases, you're not going to want to create issues that don't exist, and so there's not a definite one-size-fits-all rule for these situations. Different cases are going to demand different tactics on your part. So I would agree that in some cases, if it's not an issue, don't bring it up. However, there are other cases where you know this is going to be coming, so I want to kind of focus on that as we conclude the presentations here. Battling the CSI effect really in those cases where this is an issue or it's going to become an issue starts long before the trial starts. I think it's important early on in the life of one of those cases where you know it's coming to start thinking about how to manage these expectations about the evidence that's going to be coming in or not coming in. And these expectations may relate to the limits of particular tests and forensic technology, evidence quality and quantity limitations inherent in the relevance of evidence and its context, as I previously discussed. The perceived need by jurors to see that redundant testing is performed, and by that I mean, for example, testing every drop in a bloodstain pattern. And this also may relate to the absence of evidence in a case, and negative evidence that we've spoken about. Unrealistic expectations can come from jurors and their assumptions, mistaken beliefs, and misunderstandings about the evidence in forensic science and its capabilities. But these can also be encouraged and manipulated by defense attorneys who might see jurors as vulnerable to their manipulation and misinformation about the capabilities of forensic science and what questions it can realistically answer based on the evidence before a particular technician or an analyst. So unrealistic expectations can be fostered by jurors and by defense attorneys, but they can also be fostered by state's witnesses, such as investigating officers who may be unfamiliar with limitations of certain kinds of forensic tests or the limitations inherent in the samples themselves that they collect. So they can unwittingly set up lab analysts for criticism at trial because the analyst would not or could not comply with the investigator's request for analysis for very valid scientific reasons. So a three-step plan of attack against the CSI effect is to, first of all, anticipate the potential facts in a case that might cause jurors acting on their own or with a little help and manipulation from a defense attorney to have unrealistic expectations about the evidence or the capabilities of forensic science to answer the questions asked and the issues posed by the facts. Second, once these areas have been identified, plan to address these areas early in the case and often throughout the case, as Norm just described. And third, explain and educate the jury about the rationales that underlay evidence collection and testing decisions in the case. So the first step is anticipation. How do you do this? Just consider the nature of the case through the eyes of a layperson who is completely uneducated in the capabilities and limitations of forensic testing and the potential of the evidence to answer the questions posed. If you yourself are unfamiliar with the limits of forensic testing and the ability of different types of evidence to answer questions in a case, the first step is to become educated yourself before you try to educate the jury. Your lab analyst really is the best source of this information, so meeting with him or her early and often in the process, as often as is necessary, is really essential to getting a handle on these questions. Based on the nature of the case, the nature of the facts, and the status of the evidence, you need to ask yourself, what are the expectations and misunderstandings that an average juror might have about the questions that forensic science can realistically answer in this case? And this process can be facilitated by a thorough review of the case file and the lab reports. Try to identify items that may have been referenced by investigators but not collected, and also any items that were collected but not tested. Meet with the investigators who processed the crime scene, talk to them about why they collected certain items and not others, and the reasoning behind those decisions. Talk to your analyst at the lab about the scientific reasons why certain items were tested and while others were not. And most of the time, most often, you're going to find that there were very good case-specific, logic-based, and evidence and technology-driven reasons behind the decisions they made. In addition to meeting with your witnesses, defense interviews and depositions, if you have depositions in your state, as I do in mine, they're a great source of information about where a defendant, a defense attorney is going. And you're going to know early on, if you attend these interviews and take careful note of what's being asked, where they're going to go in relation to the so-called CSI effect. Now, the common law in many states holds that police are not obligated to collect evidence at a crime scene. And they're also under no obligation to test it after it's been collected. And if this happens to be the law in your state, as it is in mine, one strategy is to file a pretrial motion in limine seeking to exclude any reference to the fact that the police did not attempt to collect certain items of evidence, such as, for example, fingerprints. The motion can also seek to prohibit the defense from referring to items of evidence collected by police that weren't later tested. Now, even if a motion of this nature isn't sustained, by forcing your opponent to answer and argue against it, he or she will have to explain to the court where they plan to go with cross-examination and argument on this issue, so you'll have a preview of the defense attack that will better allow you to prepare yourself and your witnesses for direct and cross-examination, as well as better responding to their arguments in summation. So, as a preemptive tactic, it's not a bad idea to file a motion even if it's not going to get sustained by your judge or your court, because it may elicit some important information anyway. Once you've anticipated what the issues may be that surround the evidence not collected or the evidence collected but not tested, as well as other potential misunderstandings and unrealistic expectations that the jury may have or be open to manipulation about, I think it's important to be upfront with the jury and to address these issues early and often, again, on a case-by-case basis. As Norm said, this can start with jury selection, with some specific questions about, for example, whether anyone on the panel will require the government to offer a specific category or class of evidence, such as DNA, in order to find that you've met your burden of proof. Depending on your jurisdiction, you may develop enough of a record to eliminate potential problem jurors from your panel, and you're going to also, at the same time, precondition the rest of the panel not to expect to see or hear about a certain category or class of evidence that won't be offered. At the same time, you're getting their implicit commitment, or maybe their explicit commitment, that they won't require you to present a particular type of evidence in the case. Then, in opening statement, explain what the evidence is as well as what it isn't, and the limitations and the capabilities of the evidence and the technology, in addition to the logic and relevance-based reasons why certain items of evidence were tested and why certain items were not. In this phase of the trial, you can speak freely. It's opening statement, and you can detail to the jury information about evidence without strict time limitations. So make the most of this opportunity to explain, educate, and dispel myths and misunderstandings about the evidence and the technology. Subject to a few inevitable mistakes that may be made regarding potential evidence collection and testing decisions, I think you're going to find that most of these decisions made by investigators and analysts were well-founded, based upon their training and their experience, and based upon the best information that was then available. And it's important to highlight their expertise, their skill, and their training, as Norm stated, in making evidence collection and testing decisions to your advantage. During direct examination of your investigators and your lab analysts, it may be important to give an explanation of not only what was collected and tested, but maybe more importantly, the reasons why certain evidence items were chosen for collection or testing and others weren't. Crime scene investigators they're simply not highly paid garbage collectors at crime scenes who should collect everything in sight, pick it up, and put it in a bag. And likewise, lab analysts aren't factory workers on an assembly line who should be blindly processing everything collected by the police. There are certain questions posed by the unique facts of every case and the physical evidence recovered in relation to those facts. And that evidence and those facts should be closely examined, and the evidence should be tested, and only that evidence that sheds relevant light on the issues in that case based on the evidence and the facts in that case. It's the job of the case investigators in the crime lab to answer those relevant questions, but not to perform testing for the sake of not having to answer irrelevant questions posed later by a defense attorney. So if you want to address investigative effort and emphasize that, do it by showing that investigators and analysts work smart instead of just working hard. When combating the CSI effect, the key really is to educate and not to enable. Enabling a juror's unrealistic expectations, for example, by over-testing evidence, can be analogized to feeding an addiction instead of facing it head-on. In the CSI context, this means collecting every item of evidence at a scene or testing every item of evidence just because it's been collected, because you think that's what the jury's going to demand. But my point is, don't answer juror ignorance with irrationality. A much better strategy is to anticipate the issues, explain the basis for the evidence collection and testing decisions that were made, and educate the jury rather than enabling their unrealistic beliefs by irrational over-testing. So if it's anticipated in a particular case that the CSI effect may arise, the limitations of forensic tests and technology should be explained. If testing is not performed or is inconclusive or incomplete because of limitations inherent in the quantity or quality of the sample or the samples collected, these limitations should be fully and completely explained to the jury. If you don't explain it to them, they're going to come up with an answer later in the jury room, and it may not be the one you want. If evidence is not chosen for testing because of its limited or non-existent probative value, the factors that led to the decision not to perform testing should also be explained, as was covered in a previous section of the presentation that dealt with evidence collection and testing decisions. The reasons why multiple samples of different parts or portions of the same item of evidence were not tested, for example, only testing one sample of a large blood stain pattern should also be explained. And finally, in some cases where there was no forensic evidence recovered, in a case where there may be a reasonable expectation from the nature of the crime that it should have been, it may be very important to have an expert testify that the absence of evidence is not necessarily evidence of the defendant's absence at the scene of the crime. This can be effectively done by testimony about the transferability of different types of evidence, including the expert's training and experience, as well as the scientific literature available. In closing argument, reaffirm the jury's pledge, as Norm stated, that they would not hold you to presenting a particular category, form, or type of evidence. Secondly, review the testimony they've heard about the logic and relevance-based evidence collection and testing choices and the decisions made by experts in the field. And finally, remind them of the power of testing results from probative evidence, the danger of testing misleading evidence that has no connection to the crime, and the fact that the absence of evidence is not evidence of absence.
All right. Thank you very much, Ted. I think that this is all blending together now as we come to the end of our formal presentation. It raises a lot of questions, a lot of issues for me that I think just drives home so many important points that sometimes people overlook in the relationship building that you need to do inside and outside the courtroom. But I'm sure you guys have some thoughts as the three of you who have been speaking that you might want to expand on some of the points you made, or bring up some other points mentioned. And Mitch, let's start with you if you have any closing thoughts.
Okay, this is Mitch Morrissey, the Denver DA. I mean, I think it's obvious that you have to talk to your potential jurors during voir dire about this effect. But if you think about it, we dealt with people that enjoyed reading mystery novels. Perry Mason used to be a show that was on TV when I was a child where someone would stand up in the back of the courtroom and confess every week. And then there was Quincy, which was a very bad 1970s ME show that we had to deal with to some degree in the court. Obviously, these CSI cases is a phenomenon that is out there and you can't ignore it. But I think it's really important that when you're presenting evidence to a jury, you want to show them that this was not a case that was solved in an hour minus the TV commercials, which is what CSI is. This isn't necessarily a slick business. Your people, I always ask jurors if they're fans of CSI, and I'm going to have some people from the crime lab come in and recognize the fact that none of them are going to look anything like the people that are on CSI. Usually get a laugh, and it usually make the point then that it is fictional, these are actors, and that they want to hear what the evidence is in this case and what that evidence proves. I think that Norm and Ted hit very much on what you'll see even when you have forensic evidence, and that's the old technique or strategy from the defense that too much is not enough. And you can test and test and test, and in many cases you get very good forensic evidence, and that too much is not enough is always going to be the defense in those cases. There are some cases where forensics just can't help us. I think you need to have a witness that can explain that so you can then go into that in your closing argument and not waste resources. Remember that the too much is not enough strategy is out there, but you've got to stay focused on what you have. And like Norm said, you brought the charges, you know your evidence, you know why you believe you can prove the case beyond a reasonable doubt, and you need to focus on those things and not be distracted by the CSI effect.
Thank you, Mitch. Ted, do you want to add any thoughts as we move forward? And out to our audience out there, I just want to let you know someone has weighed in with a question in the Q&A chat section, and if anyone else wants to queue up a couple of questions, we can have those after we finish with our closing comments. Ted?
I'm a believer that the CSI effect is not necessarily something that comes from the show CSI. I think it may have made jurors more aware of forensic science, particularly DNA. But I think the problem is that prosecutors, primarily in presenting their evidence, are leaving lots of questions opened based upon the facts of the case, and they're not addressing them. If you go about this process of trying a case with forensic evidence like you're going through a laundry list and you read off all of the questions that someone else gave you or that you think establish your elements, and there are all these collateral questions hanging out there about what got collected and not tested or what never got collected to start with, and you don't address those issues head on, uncertainty makes people very uncomfortable. And especially when they've been sworn as a juror and they have someone's life at times literally in their hands, and they're wondering why they didn't hear something about a particular aspect of the case, or if they did hear something about evidence, why wasn't it tested or why wasn't something done? And that goes unanswered. That can make some people very uncomfortable when they have someone's life in the balance. So I think the biggest blame for this effect, to the extent it exists, is not on a TV show. I think that has raised the awareness, but the blame for what jurors do or do not do in a courtroom in many cases can be pointed right back at us prosecutors, because there are these issues out there that are not addressed. And the jurors are going to go up there with an information vacuum, and if you've been a prosecutor for a while, you know what happens up there. They're not going to leave the question unanswered. They didn't hear it in the evidence, but they're going to find an answer to it. Amongst the 12 of them, they're going to make up their mind. They're the finder of facts. They're going to say, here's what we think happened, and then, you know what, for all practical purposes, that's reality, because they're the finder of facts. So if these questions go unanswered, and again, let me emphasize, I, like Norm, am not someone who wants to come into a case and preemptively raise issues that aren't there. But if the issue is there, or you know it's going to be there, those are the times and those are the cases where you need to address it head on and don't act like it doesn't exist. So be proactive, anticipate, address, and educate.
Fantastic. Thank you, Ted. And Norm's going to bring us home. Some reflections.
I simply would like to just add and maybe reemphasize what I spoke about before about this special relationship that we have with the jurors. And I truly believe that it exists, and no one else in the courtroom has that relationship. The jurors are looking to us to give them what they need to make their decision. And it's just incumbent upon us to give us that, to give them what they need to make the decision. Our burden of proof beyond a reasonable doubt, that we use at trial is the same burden of proof that they have to use in their deliberations. And that really develops what I think is that special relationship for them. Also, one of the aspects of CSI that we can't lose sight of is that all the CSI programming and their spawn show bad people getting caught by good guys. And the good people are protecting the public. They're righting wrongs, and they're holding people responsible for their conduct. And that's what these shows depict. And these jurors want to see the good guys thoroughly investigating crimes, using technology, scientific technology when available. They just want to see competence, I believe. And it's easy for us to give that to them. And we should just do what we always do, present the evidence in a simple, polished, and well-organized fashion, and use visual aids like PowerPoint whenever you have the opportunity to do so, to bring to life in the courtroom that crime scene and all the evidence that was developed from the investigation of the crime. And if necessary, somehow show the jury that the lack of forensic tests does not equate with insufficiency in the prosecutor's proof. Thank you so much.
Thank you, Norm. And stay right there. You're in the hot seat, because I think that as we move to questions, we have a question that's really directed to your presentation about stipulating the evidence.
Yes, I see that. Okay, I will read the question. In a lengthy trial, 2 weeks or months, where the defense counsel offers in front of the jury to stipulate the chain of custody, would you still not stipulate? Can we show the quality of the investigation in other ways that will not alienate the jury? Let me answer this. I've had that happen to me. In fact, I had it happen to me recently in a lengthy trial. It was a serial sexual assault case, cold case. Sexual assaults had happened back in 1994, and we just went to trial a year ago, and 5 victims. And again, I was putting in all the chain of custody in the case, all the evidence, calling everyone who had any handling of that case, of the evidence. And sure enough, didn't the defense attorney stand up in front of the jury, as the question states, and says, we'll stipulate to all that. And I looked at the judge looked at me, and I said, Judge, I appreciate the offer, but I think it is important for the jury to just see how these professionals maintain the integrity of all this evidence. And I left it in that, and the judge said, proceed. And I see where the question here says, it talks about in other ways that will not alienate the jury. I don't think it alienates the jury. And let me tell you why. When it came time for closing argument, I got up in front of the jury and I looked at them and I said, I called a lot of chain of custody witnesses. All of you know all about chain of custody now. And I saw, when I was bringing this tedious testimony in front of you, and I saw you rolling your eyes sometimes, so you jurors doing that. But I did this for a reason. I think it is so very important for that when you go back to that deliberation room, that you have faith and trust in the integrity of this evidence, that evidence that was picked up at that crime scene was taken care of properly, transported properly, preserved properly, and analyzed properly, so that we got the DNA result that shows that this person is the source of that semen from the crime scene. And they accepted that. And you could even see a few smiles on their face when I went into their rolling their eyes and the tediousness of the testimony that I presented. But no, I think it's important. And also in a sexual assault case, I believe that presenting the chain of custody sends sort of a subliminal message to the jurors that everyone believed her, that they took such care and so concerned with it. I think it sends that message. I think it's important, and I like to put it in. Hope that answers your question.
Okay, there's another question on the board about over-testing, and Mitch, do you want to handle that one?
Yeah, it's I'm not real clear. The question says, in a lot of investigations, especially major crime investigations, much forensic work is done to establish the perpetrator. I understand Mitch's concern to not overdo testing, but it frequently is done to solve the crime. Is it important not to put this out? I think that it's very important to keep in mind that, and there is sometimes forensic work done to solve the crime, and additional forensic testing can be done then to help you deal with the issues that you're confronted with the case. And I obviously think there should be limitations on the ability to request testing, but in the situations that I'm talking about, if we're talking about a major investigation, DNA work was to help you identify the perpetrator, and that got you to the point where you could bring charges. Obviously, if there's additional items of evidence that are going to help you combat, say, a consent defense or combat a self-defense, things that maybe come to your attention during the course of the pendency of the case pre-trial, you can ask for additional testing. I'm not real clear on, is it important to put this out? I'm not sure exactly what the question is in that regard. But if it helps you prove the elements of your case, or to a degree it helps you explain why you don't have that evidence, then I'm all for doing the forensic testing.
If anybody else has questions, feel free to add to the queue. Otherwise, we're gonna wrap this up. Unless Ted, did you want to address either of those questions?
I think I understand the question. There's a lot of testing that occurs to try to solve the crime, to identify the perpetrator, that may cast a wider net than what would be advisable if we had a profile, for example, that identified a good suspect and then narrowing the focus of the testing. I think that's inevitable in any case, and I think it's going to be a much wider net, but still, we live in a very dirty world, and with the significance and the sensitivity of DNA testing, you're going to get a profile if you look hard enough. If you swab enough surfaces, depending on what you're doing, you're going to get a profile. Now, the question becomes, is that probative or not? If I was a detective, my scope would probably be a little bit larger than it would be if I'm a prosecutor, because you're operating in a vacuum. You don't know who your suspect is. On the other hand, we as prosecutors probably shouldn't be testing all of the cigarette butts 2 or 3 rooms over in the ashtray from where the murder victim is found. And if we do have somebody charged, what good is that really going to do us? Now, again, it's a case-by-case situation, and every jurisdiction is going to be a little bit different. But to directly answer the question, I think yes, you ought to put out the reasons why there was a wider net cast, why some evidence that may be on the outer edge of what may be probative or relevant based on an examination of the scene, those items should be brought up, and the reasons why that was tested should be brought out. And I don't think that's something that you should necessarily hide, and you wouldn't be hiding anyway, because in that case, that's something that probably led to your suspect. But in the cases where it didn't, and you turn up irrelevant profiles, you're going to have to put on negative evidence in those cases as well to talk about the other potential reasons that profile, for example, showed up that has nothing to do with the crime. Could have been placed there before the crime, could have been placed there even after the crime but before investigators showed up. So I think those things are not intuitively apparent to jurors, and yes, I would bring that out.
Okay, thank you to all of you guys. If there's no more questions, we're going to let everybody go to lunch or go to work. Thank you very much for tuning in. This is great to have an audience to listen to this program on managing the CSI effect. And I just want to say thanks again to all of our panelists, Norm, Ted, and Mitch. I want to say thank you to Bruce Bicknell, who's here at the National Forensic Science Training Center, helping us put this on out there for you. And I want you to feel free to contact me. This is, again, Maria Beeman with the Justice Management Institute. If you have questions or need further information, we will be posting this PowerPoint on the National Forensic Science Training Center's website. After the program is over, we will send an email out to everyone who's signed up for the webinar. So with that, thank you very much and good day.